Good evening and welcome to the Iowa State Bar Association People's Law School program, Brown versus Board of Education, an overview and conversation. My name is Henry Hamilton III, and I will serve as moderator tonight. This Black History Month program is co-sponsored by the Iowa State Bar Association, the Iowa chapter of the National Bar Association, the Polk County Bar Association, and Iowa, the Iowa Organization of Women Attorneys. The Iowa State Bar Association's People's Law School program provides free educational events where members of the public can find answers to life's questions. Speakers present information on a variety of legal topics and answer questions. Programming focuses on a variety of issues impacting Iowans, including the basics of wills and revocable trusts, buying and selling a home, mortgages and foreclosure, establishing guardianships and conservatorships, modifying child custody and visitation degrees, and much more. We are thoroughly excited about tonight's program on one of the most significant cases in our country's history, Brown versus the Board of Education. We will first hear a presentation from Ames, Iowa attorney Tim Gartin. Following his presentation, we will have a panel discussion featuring judges Emily Chafa and Odell McGhee, following a summation by Attorney Gartin. We welcome Attorney Gartin to the Iowa State Bar Association People's Law Program. Tim Gartin is a partner in the Ames firm of Hastings, Gartin Boettger, LLP. He received his BA from Iowa Wesleyan College, his MA from Iowa State University, and his Juris Doctorate from Northern Illinois University. Tim is a 25-year member of the Story County and the Iowa State Bar Associations. He is serving in his third term on the Ames City Council and teaches business law to undergraduate students at Iowa State University. Tim is also an active member of the Ames chapter of the NAACP. Without any further ado, Attorney Gartin, we're looking forward to your presentation.
Thank you, Judge Hamilton, and it's great to be with everyone today. As I start today, I want to share with you a little story. Several months ago, my wife asked me a question. She said, Tim, you seem pretty obsessed with this topic of Brown versus Board of Education. Why is this so compelling of a topic for you? And that was a fair question. And so 3 reasons to get us started today of why this is such an important topic for me. The first is somewhat academic. It is one of the most important U.S. Supreme Court cases we have. It corrected a very important wrong case in Plessy versus Ferguson, and it provided hope to millions of Americans. But there has to be more than even that. The second reason why this is important is that the struggle for civil rights is not over. And so if we're going to understand where we are, we have to know how we got here. And so if you're interested in issues of education or racial justice, this story is actually really important for you to know. But even beyond that, I think it's important to know both the good and the bad of our country's history because it's our history. And so as like in any individual, there are some things we wish we would have done differently. There are things in our country's history that are not as good as well. Churchill said, a nation that forgets its past has no future. Now, oftentimes this type of topic is thought about as being African-American history. And I suppose that's true, but in a much broader sense, this is all of our history. And so even though there are going to be some difficult chapters, I hope that you're able to see along with me that there are some wonderful heroes, some examples of courage that I hope you will find encouraging today. So where do we go from here? So I'm going to be addressing several questions. First, what is the legal background of Brown? And so we're going to start with the Civil War amendments and work our way up through the beginning right before Brown. We'll look at the 4 other cases that make up the consolidated case of Brown versus Board of Education. We'll look at Brown itself and its aftermath, and then we'll shift to an amazing panel. And I hope all of you are able to stay on the Zoom call today for this incredible panel, and I'll come back then to wrap things up. You should have received a handout that I hope will be helpful as you go through the material today. It includes a lot of the quotations from these cases and the basic structure of where we're going, and I hope you find it a helpful resource. For those of you who are teachers, there are a series of discussion questions at the end that you might find helpful. I have also included a copy of Brown versus Board of Education, the opinion itself. It's not a very long opinion, and if you've never read a U.S. Supreme Court opinion, this is a good first one to read. So let's begin with the background of Brown versus Board of Education. So as you know, the American Civil War went from 1861 to 1865. In the course of that war, and the numbers varies a bit in terms of who you look to, but somewhere in the neighborhood of 700,000 people died in the course of the American Civil War to right this injustice of slavery that was inserted into the Constitution. Following the Civil War, there was an effort to amend the Constitution to make sure that there were certain wrongs that were corrected constitutionally. And we call these three amendments the Civil War amendments. So the 13th Amendment was added in 1865, and it abolished slavery. The 14th Amendment, a few years later in 1868, and this provided for citizenship rights. So it basically fixed what happened in Dred Scott. It provided for due process and equal protection of the laws for all people. And let's take a look at the specific language of the 14th Amendment, because that's what our case turns on today. So Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state, and underline that, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state, underline that, deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of its laws. Let me read that one last time. Nor deny to any person within its jurisdiction the equal protection of the laws. Well, what does that phrase mean? Well, we're going to wrestle with that today. The 15th Amendment prohibits discrimination in voting rights on the basis of race, color, or previous condition of servitude. And as you may remember, the 19th Amendment, which was adopted in 1920, prohibited states and the federal government from denying the right to vote on the basis of sex. Historian Eric Foner, who has done tremendous work in the area of the Reconstruction period, calls this period the second founding. So as you may remember, the Bill of Rights was adopted to hold the federal government in check. That was the concern at that point. But the Civil War amendments were adopted to protect our rights from the infringement from state governments. Now, before we go into the story of the history of federal cases, I want to spend just a moment talking to you about a very important case for those here in Iowa called Clark versus Board of Directors. This is a case from 1868. So in 1867, the year before the ratification of the 14th Amendment, 12-year-old Susan Clark was denied the ability to attend grammar school number 2 in Muscatine, Iowa, because she was Black. Her father filed suit, and the Supreme Court ruled in 1868 that when Article 9, Section 12 of the Iowa Constitution says, the Board of Education shall provide for the education of all use of the state through a system of common schools, this means all use. And I love the quote, all use are equal before the law. What a beautiful sentence that is. And it is unfortunate that it took the rest of the country so long and there was so much pain to arrive at that same conclusion. There was some great language from the court's opinion. Our statute does not either in letter or spirit recognize or justify any such distinction or limitation of right or privilege on account of nationality. For the courts to sustain a board of school directors or other subordinate board of officer in limiting the rights and privileges of persons by reason of their nationality would be to sanction a plain violation of the spirit of our laws, not only, but to perpetuate the national differences of our people and stimulate a constant strife, if not a war of races. Well, that brings us then to our federal cases. And there are two that I'm going to mention ever so briefly, although they deserve much more attention. The first is the Slaughterhouse Cases from 1873. The Slaughterhouse Cases basically held that the 14th Amendment only protects legal rights involving federal citizenship and not state citizenship. And this gutted the Privileges or Immunities Clause. Then the Civil Rights Cases from 1883 said that the 13th and 14th Amendments did not empower Congress to outlaw racial discrimination by private individuals. And this case struck down the very important Civil Rights Act of 1875 and allowed for widespread discrimination. If you've not heard of the Civil Rights Act of 1875, it was really the work of Charles Sumner, and it created full access for inns, public conveyances, theaters, public amusements, regardless of race or prior servitude. And the civil rights cases took this away. And then this case really set the stage then for the very important Plessy versus Ferguson in 1896. So what happened in this case? So in 1890, the state of Louisiana passed a law that required separate accommodations for Blacks and whites on railway cars. A committee in New Orleans created an effort to challenge this, and they persuaded Homer Plessy, a man who was of 1/8 of African descent and 7/8 European descent, to be the test case. They were interested also in testing the definition of what it meant to be Black under the law. So Homer Plessy bought a first-class ticket and sat down in the whites-only car. The committee had arranged for a private detective to arrest him and charge him with violating the Separate Car Act, and he was convicted. This was all part of the plan. Louisiana court affirmed, and the case was appealed to the United States Supreme Court, in part on the 14th Amendment Equal Protection Clause. So all of this was done according to plan. The U.S. Supreme Court held, however, that the Louisiana statute did not violate the 14th Amendment. So the separate cars was okay. And I'd like to take a look at some of the language from the majority opinion from Justice Brown. This language is a bit startling for us. The object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law, which is startling by itself if you think about that statement by itself. But in the nature of things, it could not have been intended to abolish distinctions based on color, or to enforce social as distinguished from political equality or a commingling of the two races upon terms unsatisfactory to either. Laws permitting and even requiring their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally, recognized as within the competency of the state legislatures to exercise of their police power. The most common instance of this is connected with the establishment of separate schools for white and colored children, which have been held to be a valid exercise of the legislative power, even by the courts of states where the political rights of the colored race have been longest and most earnestly enforced. So the court is saying there that the separation of the races does not necessarily imply inferiority. In fact, the court goes on to say that if there is a sense of inferiority, it's because the colored race chooses to put that construction upon it. Thus, the Louisiana statute did not violate the Equal Protection Clause of the 14th Amendment on the basis of racially segregated facilities where the facilities were equal in quality. And this was the beginning of what we now know as the separate but equal doctrine. So many people are not aware that there was a dissenting opinion to this majority opinion. And frankly, it's one of the most important dissenting opinions in our country's history. And it was written by Justice Harlan. And there are two quotations from this that I think are particularly noteworthy. The first is the idea that our Constitution is a colorblind Constitution. Justice Harlan. But in view of the Constitution, in the eye of the law, there is in this country no superior, dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights are guaranteed by the supreme law of the land are involved. It is therefore to be regretted that this high tribunal, the final expositor of the fundamental law of the land, has reached the conclusion that it is competent for a state to regulate the enjoyment by citizens of their civil rights solely upon the basis of the race. Just amazing language. And finally, the second quote, the destinies of the two races in this country are indissolubly linked together, and the interests of both require that the common government of all shall not permit the seeds of race hate to be planted upon the sanction of law. Under the sanction of law. What can more certainly arouse race hate? What more certainly create and perpetuate a feeling of distrust between these races than state enactments which in fact proceed on the ground that colored persons are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens. Amazing language. This language, I think, has inspired many. And I can't help but reference the very famous work of Dr. King, A Letter from Birmingham Jail. And I want to just quote a little bit of this from Dr. King, because you'll hear this thread that you first see in the minority opinion of Justice Harlan. Listen to this. Moreover, I am cognizant of the interrelatedness of all communities and states. I cannot sit by in Atlanta and not be concerned about what happens in Birmingham. Injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly. Never again can we afford to live with the narrow provincial outsider agitator idea. Anyone who lives inside the United States can never be considered an outsider anywhere within its bounds. So, Plessy versus Ferguson, 1896. And so what are the legacy aspects of that? Well, state legislatures then were given license to require separate institutions as long as they were equal. And so public schools, public places, public transportation, restrooms, beaches, swimming pools, restaurants, drinking fountains, hotels, motels, all became normal. And these laws were known commonly as the Jim Crow laws. And such laws also spread to the north. And they were supported by a climate of lynchings, which suppressed any resistance. Now, there are a couple of terms that are very helpful as we approach this topic. The first is this idea of de jure segregation, and the second is de facto segregation. De jure segregation is state mandated segregation. De facto segregation is segregation that happens voluntarily without a state mandate. And so what we're seeing here is de jure segregation in public schools. Well, let's take a look now at the civil rights cases leading up to Brown. Now, I want to make sure that we talk a little bit about some of the important personalities that were involved in this effort. Charlie Houston was the chief architect of the NAACP legal strategies, and he was the chief legal counsel from 1935 to 1940, when Thurgood Marshall, age 30, was named as Houston's replacement. And a case came in 1938 that was a major precedent. State of Missouri X-Rail Gaines versus Canada. Now, this has nothing to do with the country of Canada. Silas Canada happened to be the registrar of the law school at the University of Missouri. So in this case, Lloyd Gaines was a qualified Black student, and he applied for admission into the University of Missouri School of Law. However, this law school did not admit Black students. And so the state offered to pay for the tuition for a comparable out-of-state school that did admit Blacks. However, the Supreme Court found that this was not a viable substitute. The state of Missouri could not provide legal education for whites only, but they left a separate but equal in place. This was a very important case. Following this, during World War II, we had the Karamatsu versus United States case in 1944. In Karamatsu, the United States Supreme Court ruled that an executive order which ordered Japanese Americans into internment camps was in fact constitutional. Besides the controversy the decision caused, it did introduce the concept of strict scrutiny regarding racial restrictions. The court held it should be noted to begin with that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect. That was a very important sentence. This is not to say that all such restrictions are unconstitutional. It is to say that courts must subject them to the most rigid scrutiny. Pressing public necessity may sometimes justify the existence of such restrictions. Racial antagonism never can. This was very important language for the court. And finally, during World War II, we had the phenomenon that African-American soldiers who were returning from war left from fighting the racial animus of the Nazis to come home and find themselves as second-class citizens in the United States. And they participated heavily in much of the unrest. In 1946, the NAACP Legal Defense Fund was formed, and it was led by Thurgood Marshall. And it had two goals. The first was to demand equal schools under the separate but equal doctrine, but also to challenge Plessy. Now, the strategy at this point in 1946 was a slow and incremental approach. The next major case that took place was the important Shelley versus Cramer in 1948. And this involved racial restrictions on property ownership. Now, this case is very interesting for many reasons. And even though this case did not involve situations in Iowa, it is important to note that even in Iowa, we did have restrictive covenants that were based on race. Even in the community that I live in Ames, we had several subdivisions that had racial prohibitions that Black people could not live in those subdivisions. The case is also interesting because three of the justices had to recuse themselves. Justices Reed, Jackson, and Rutledge all owned real estate that was bound by restrictive covenants that had these kind of racial bars. This case involved restrictive covenants from Missouri and Michigan. And the issue is whether such restrictive covenants would be held to violate the Equal Protection Clause of the 14th Amendment. And so the court found that such restrictions did violate the 14th Amendment. And let's take a look at some of the language. This case, this opinion was authored by Chief Justice Vinson, who will play an important role in our story today. And it was a unanimous 6-0 opinion because of the recusals. Listen to this language. Because of the race or color of these petitioners, they have been denied rights of ownership or occupancy enjoyed as a matter of course by other citizens of different race or color. The 14th Amendment declares, what is this, but declaring that the law in the state shall be the same for the Black as for the white. Understand how significant this language would have been to the hearers in 1948. That all persons, whether colored or white, shall stand equal before the laws of the states, and in regard to the colored race, for those for whose protections the amendment was primarily designed, that no discrimination shall be made against them by law because of their color. This was very, very earth-shattering language for the court to issue. Equal protection of the laws is not achieved through indiscriminate imposition of inequalities. I'm going to read that one more time. Equal protection of the laws is not achieved through indiscriminate imposition of inequalities. And so, and finally, the court held, and it would appear beyond question that the power of the state to create and enforce property interests must be exercised within the boundaries defined by the 14th Amendment. So this case, Shelley versus Cramer, was foundational for what was going to happen later in Brown. Now, a few more other aspects. The Cold War politics of the time have to be noted. So the Soviet Union made much of the fact that in the United States, we did not treat the races equally. And so this had an effect on the moral platform of the United States in condemning the human rights abuses of other countries. And then on June 5th, in 1950, 2 years after Shelley, there came two decisions on the same day, June 5th, 1980, that shook the world. The first was Sweatt versus Painter. This was another law school admissions case, and this was argued by at that point, the attorney Thurgood Marshall. Now, in the facts of this case, Heman Sweatt applied to admission at the University of Texas Law School. He was denied admission because he was Black. Texas had no law school at that point for Black students. Now, if this sounds familiar, it should. That was the situation with the prior case in Missouri. Sweatt filed a petition arguing that he was deprived equal protection under the law by the 14th Amendment. The court did not grant him relief, but gave 6 months for the state to allow them to comply. In response, Texas said, well, we know how to fix this, and it opened a law school for Black students. And Sweatt refused to apply and continued to press his claim because the two schools were not equal. He lost at every level, but the U.S. Supreme Court took his case on appeal. And the question then is, to what extent does the Equal Protection Clause of the 14th Amendment limit the power of a state to distinguish between students of different races in professional and graduate education in a state university? And the court held that the Equal Protection Clause requires that Sweatt be admitted to the University of Texas Law School. And this opinion was written by Chief Justice Vinson. And he reached this opinion without re-examining Plessy in light of the effects of racial segregation. The court compared the objective differences between the University of Texas Law School and the Law School for Negroes. There were substantial differences in the number and caliber of the faculty, the number of volumes of law library, and other attributes. And listen to this language. Equal protection of the laws is not achieved through indiscriminate imposition of inequalities. And so because the law school for Black students would not have white students, it would be deprived of contact with people who would be their colleagues as attorneys, witnesses, jurors, and judges once a member of the bar. Very important language. Equal protection of the laws is not achieved through indiscriminate imposition of inequalities. So you can sort of feel the court moving closer and closer to addressing Plessy versus Ferguson in Brown. The same day, you had Mclaren versus Oklahoma State Regents for higher ed. This was a graduate admissions case. G.W. Mclaren was a Black applicant for a PhD in education at the University of Oklahoma. And after being denied because he was Black, he was admitted through a federal district court, but it was on a segregated basis. And it's painful even to describe how Mclaren was treated. He was required to sit at a designated desk in a different room adjoining the classroom. He was not allowed to use the regular desk in the reading room and had to sit in a designated table and to eat at different times from the other students in the school cafeteria. The issue in this case was whether graduate instruction at a state university could provide different treatment for a Black student solely because of the student's race. And the Supreme Court held that these conditions violated Mclaren's right to equal protection of the laws under the 14th Amendment. And once again, this was Chief Justice Vinson. And I'll let you read this opinion, but I'm going to pick out a couple of things. In the second paragraph near the end, it says, their own education development will necessarily suffer to the extent that his training is unequal to that of his classmates. State-imposed restrictions which produce such inequalities cannot be sustained. It may be argued that appellant will be in no better position when these restrictions are removed, for he may still be set apart by his fellow students. This we think irrelevant. There is a vast difference, and I love this, a constitutional difference between restrictions imposed by the state which prohibit the intellectual commingling of students and the refusal of individuals to commingle where the state presents no such bar. And you hear in this the two different types of segregation, the de jure and the de facto. The removal of the state restrictions will not necessarily abate individual and group predilections, prejudices, and choices. But at the very least, the state will not be depriving appellant of the opportunity to secure appellant by his fellow students on his own merits, acceptance by his fellow students on his own merits. This was an amazing two sets of cases for Thurgood Marshall. And so later in June of 1950, in light of these two recent victories, Marshall and 43 attorneys formed a plan now to directly challenge Plessy, arguing that these segregated schools violate the 14th Amendment. So what happened is that test cases all around the country were sought to be able to test the Plessy decision. So at that time, there was quite a difference of opinions of how states should do this. And if you take a look at your map, and Sonia, if you could put up the map, you'll see that at this time, 17 states required segregation and 16 states permitted segregation. So our country was very divided in this regard. Thanks, Sonia, for putting up that map. And that was the state that we find ourselves when we come to Brown. So many people do not realize that Brown versus Board of Education is not one case, but actually 5. And so there are 4 other cases that make up this consolidated consolidated case. So the first is Briggs versus Elliot. This was a South Carolina case. And parents, more than 60 parents sued South Carolina's Clarendon County to demand equal facilities. White children rode the buses to modern schools, but Black students walked as far as 5 miles to attend ramshackle schools. There were nearly 3 times as many Black students as white students in this county, but the white students received more than 60% of the education funds. The second case is Davis versus County Board of Prince Edward County in Virginia. And this was a very interesting case. There were 117 Black high school students who led a strike, were on strike to protest the poor facilities. And I like this case in particular because it was led by a 9th grader named Dorothy Davis. And I don't know much about Dorothy Davis, but I admire her courage. And for those of you who are in high school, it's a good reminder that even a young person can really make a difference in society. The third case is Gebhard versus Belton, and this was a Delaware case. And this case is interesting because this was the only case where the court found in favor of the parents. The parents were challenging the rules requiring their children to travel to inferior schools. And this is the only case where the courts ruled in favor of the parents. And so here it wasn't the parents and the NAACP that was appealing, it was actually the state that appealed. And finally, we have Bowling versus Sharp. And this case was filed on behalf of Spotswood Bowling Jr., and he challenged the segregated schools in Washington, D.C. But this case was actually pulled away from the others because it involved a federal city instead of a state. Now, if you're curious to know how this turned out, the Supreme Court eventually found in favor of bullying by reading the Equal Protection Clause into the Due Process Clause of the Fifth Amendment. And that brings us now to Brown. We made it. So what happened in Brown? So Oliver Brown was a welder and a part-time minister and the father of third grader Linda Brown. And he was one of 13 parents in Topeka, Kansas. And these were parents who were recruited by the NAACP to challenge segregation in Topeka, Kansas. Now, one of the things to note, in Topeka, it was only the elementary schools that were segregated. As the kids got older, they would attend integrated schools. And the thing about Topeka is that the quality of the schools between black and white schools was very close. So this was not a situation as you had in many other states where there was a wide disparity between white and black schools. And so the question here was, even where the quality of the schools was similar, does the 14th Amendment still require there to be a finding that the segregated schools were not permitted under the 14th Amendment? And I'd like to, at this point to hear from Linda Brown herself tell about her experience. Sonia, can you roll that tape? Hang on, we'll get there.
I'll see if I can pull it up. 1 second here, please.
Okay.
Oh, Sonia has it. Okay.
Okay. Thank you, Sonia.
Having us come in today to be with you and talk about Brown versus the Board of Education and our part in that historic case, and reminisce with me some 50 years ago when my family became part of Brown versus the Board of Education. It all started for me on a balmy day in the fall of 1950 in the quiet Kansas town of Topeka, when a mild-mannered black man took his plump 7-year-old daughter by the hand and walked briskly 4 blocks from their home to the all-white school and tried without success to enroll his child. The child of whom I speak was I, Linda Carroll Brown, and my father, the late Reverend Oliver Leon Brown. Black parents in Topeka felt that the day of trying to enroll their children in the school nearest to their home was long overdue. Many were the evenings my father would arrive home to find my mother almost in tears because I would get halfway to the school bus stop, which was a 7-block walk from my home. I could only make half that walk because the cold would get too bitter for a small child to bear. I can still remember starting that bitter walk and the terrible cold that would cause my tears to freeze upon my face. I would return running as fast as I could. I had to cross a very busy avenue in order to catch the school bus, which would carry me more than 2 miles across town to the all-black Monroe Public School. These were the circumstances which so angered black parents. My father pondered why. Why should our children have to travel so far to school, facing unbearable winter weather, waiting for a badly overcrowded school bus to carry them some 2 miles across town when there is a school only 4 blocks from our home? Why? Why must I have to spend time trying to explain to my child that she cannot go to school with her neighborhood playmates, who are predominantly white, Native American, and Hispanic, because her skin is black? In the face of this discouragement, he, along with 12 other parents, met with the local NAACP and their lawyer, Charles S. Scott, a local attorney, to make plans for each family to try and enroll their child in the white school nearest their home during September 1950. After trying enrollment and being turned down, a suit was filed in federal court in February of 1951. During the following July, the federal three-judge panel heard testimony from my father, along with several of the other parents, who agreed that segregated schools for blacks were unequal.
Let's pause it there. Thank you, Sonia. And we'll pick up the story. What an eloquent and amazing story told by none other than Linda Brown. So very powerful story told by Linda. And so the first oral arguments that took place before the U.S. Supreme Court took place on December 9th through 11th in 1952. And Thurgood Marshall argued that the segregated schools kept former slaves as near as slaves as possible. In his briefs, Marshall offered evidence from psychologists Kenneth and Mamie Clark. And what they did was the Clarks had studies, what they call the doll studies, involving students who attended segregated schools in Washington, D.C. and integrated schools in New York. The doll experiments involved presenting children with two dolls. The two dolls were identical except for their skin and hair color. One doll was white with yellow hair, while the other was brown with black hair. The black child was asked which one is the doll they would like to play with, which one is the nice doll, which one looks bad, which one has the nicer color, and which doll is best. In most situations, the child would say that the white doll was best and was nice. But then the black child was then asked which doll looked most like them. And this was a problem for the child. Some black children chose the white doll as the doll that looked like them because they could not brace the black doll after saying that it was not nice. This experiment showed a clear preference for the white doll among all the children in the study. And these findings exposed internalized racism in the African-American children and self-hatred that was more acute among the children attending segregated schools. Now, there were some very important developments that happened in the court. In May of 1953, Justice Frankfurter, in visiting with the other justices, saw how divided the court was and did something very unusual and asked for the court to be re-argued in the fall of 1953 to try to gain some consensus. The court also asked the Eisenhower administration to participate in the case. On September 8th of 1953, something unexpected happened. Chief Justice Vinson died of a heart attack. Now, even though Chief Justice Vinson was the author of Sweatt versus Painter and Mclaren versus Oklahoma State Regents for Higher Education, he opposed overturning Plessy. And on the way back from the funeral, Justice Frankfurter said of Chief Justice Vinson's death that this was the first solid piece of evidence he had seen to prove the existence of God. This was not a very nice thing to say, but it made a very important difference in the lineup of the court. On October 1st, 1953, President Eisenhower appointed Earl Warren, the governor of California, as the Chief Justice. And Chief Justice Warren then persuaded the holdout justices to rule in favor of Brown. On December 7th through 9th, 1953, there was a second round of oral arguments, and this was dealing with the adoption of the 14th Amendment. And then finally, on May 17th, 1954, Chief Justice Warren was able to announce a unanimous 9-0 vote to overturn Plessy as to public schools with a very short and clear opinion. However, it lacked details about how it was going to be implemented. And the court then held that Black children were deprived of the equal protection of the laws guaranteed by the 14th Amendment. And the decision overturned Plessy as it applied to public schools, although it did not fully overturn Plessy. And so I'm going to take a look now at the rationale the court used. So first of all, they noted that because public schools were very few at the time of the ratification of the 14th, that it was very doubtful that this could have been in the mind of those who ratified it. The court noted that the recent cases which held that segregated graduate schools could not satisfy the requirement of being separate but equal were very important precedents. And the court then turned to the effect of segregation on public education. And you can see the quote that I provided there. And I love this line: "We must consider public education in light of its full development and its present place in American life throughout the nation." So education then was seen as the most important function of state and local governments. And I want to read this entire quote because the language here, understand its resonance not only at the time of Brown, but also for our time today. Listen to this language. "Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity where the state is undertaken to provide it, it is a right which must be made available to all on equal terms." Such amazing language. The court then goes on to talk about the effects of on colored children because of segregation. And I love this quote here: a sense of inferiority affects the motivation of children to learn. Segregation, with the sanction of law, therefore, has a tendency to retard the education and mental development of Negro children and deprive them of some of the benefits they would receive in a racially integrated school system. So, and then most importantly, separate educational facilities are inherently unequal. So that was how the court finally ruled in Brown. So what happened as a result of Brown? Well, afterwards, and I wish there wasn't an afterwards, I wish that this was the end of the story, but it was not the end of the story. Almost immediately, what was issued then by 19 senators and 82 representatives was a document called the Southern Manifesto. And this was a document that it contests that the 14th Amendment could possibly have contemplated public school education. And some of this language is just almost untenable. This unwarranted exercise of power by the court, contrary to the Constitution, is creating chaos and confusion in the states principally affected. It is destroying, listen to this language, the amicable relations between the white and Negro races that have been created through 90 years of patient effort by good people of both races. It has planted hatred and suspicion where there had been heretofore friendship and understanding. Unbelievable. And so a year later, because many schools had done nothing to integrate, Brown 2 was issued. And this required schools to make a prompt and reasonable start toward full compliance with the May 17, 1954 ruling. And the famous language from Brown 2 is they were to act, quote, with all deliberate speed. But this language itself was seen as ambiguous enough that it gave latitude to schools in their efforts to desegregate. In fact, in Prince Edward County, one of the schools that were the part of the consolidated cases, the board of supervisors just refused to allocate money for the schools, and the schools there were closed from 1959 all the way to 1964. Now, it's important to note that in addition to these cases coming down from the Supreme Court, there's a backdrop of other important events going on in the struggle over civil rights, and I've provided those in the outline. I want to take a look, though, at efforts to integrate schools. And one of the most famous was the Little Rock Nine. In 1957, the governor of Arkansas, Orville Faubus, ordered the Arkansas National Guard to block Black students from entering Little Rock Central High School. President Eisenhower deployed 1,000 soldiers from the 101st Airborne Division from September to November to escort the Little Rock Nine into the school and federalize the Arkansas National Guard. And we're going to show you a clip here in a moment. And every time I watch this, it has an effect on me because remember, these are federal troops. These are our troops deployed on American soil to protect American citizens. This is quite a clip. So Sonia, if you could roll that tape, please.
What about you, sir? Do you think the colored students will show up?
If I got anything to do with it, they won't show up. Well, I think it's a breaking point of the school integration. I just don't feel that they have a right to go to school.
It is easy to believe today that we are an enlightened society, free from problems of race, gender, or economic separation. But some of the most difficult lessons we learn are a result of individuals who push us through these divisive barriers. In September of 1957, 9 Black school children, the eldest only 17, forced us through such a blockade. They sought a better education for themselves and the opportunity to pursue the American dream.
This is Central High School, Little Rock, Arkansas. Troops, which for nearly 3 weeks lined the sidewalk here in front of the high school under orders to keep the colored students out, have been replaced now. And their orders to comply with the law, which means let the Negro students in if they come in.
We were Terrence Roberts, Jefferson Thomas, Thelma Mothershed, Elizabeth Eckford, Ernest Green, Carlotta Walls, Melba Patillo, Minnie Jean Brown, and Gloria Ray.
They became known as the Little Rock Nine. The 1954 Supreme Court ruling on Brown versus the Board of Education found segregation of schools unconstitutional. But as the Little Rock Nine approached the high school, segregationists swarmed the campus.
They got no business out here. This is our school, not theirs. They are their own.
As the violence escalated, one schoolgirl, Elizabeth Eckford, was threatened by an angry mob chanting, "Lynch her, lynch her." President Dwight Eisenhower intervened in Little Rock and set a precedent for our nation as a whole.
Such an extreme situation has been created in Little Rock. This challenge must be met, and with such measures as will preserve to the people as a whole their lawfully protected rights in a climate permitting their free and fair exercise. In the present case, the troops are there pursuant to law, solely for the purpose of preventing interference with the orders of the court.
On September 25, 1957, the 101st Airborne Division and 10,000 National Guard troops escorted the Little Rock Nine as they walked bravely past screaming mobs and made their way to the classrooms of Little Rock Central High School.
Just got a report here on this end that the students are in.
Do you feel it's worth it going through this?
Yes, I do.
These 9 heroes were willing to step forward and in doing so altered the course of history. Marquette University is honored to bestow upon them the Pierre Marquette Discovery Award for this extraordinary contribution to the advancement of education for all people. The Little Rock Nine stand not just for racial equality, but also for the promise upon which our society is founded: opportunity and equality for all willing to strive, struggle, and achieve.
That's a very moving piece, and truly the Little Rock Nine are American heroes. The Supreme Court became involved in the Little Rock case in a matter called Cooper versus Aaron in 1958, and it held that the school board surprisingly had acted in good faith because of its delays that were due to the state government, and denied the request for a desegregation plan for another 2.5 years. There were some other noble instances of courageous efforts to integrate schools. And I wish we had more time to unpack all of these, but I want to just provide these to you. Authoring Lucy was the first Black student at the University of Alabama in 1956. James Meredith, which I'm just learning more about, absolutely fascinating story. First Black student at the University of Mississippi in 1962 after the intervention of President Kennedy. And once again, troops were brought into the campus to facilitate James Meredith being able to attend. Medgar Evers, another American hero, sued to desegregate the schools in Jackson, Mississippi in 1963 and was murdered by the White Citizens Council member Byron Della Beckwith. And after 2 hung juries, Beckwith was not convicted until 1994. And in 1963, Governor Wallace blocked the door to a building at the University of Alabama, blocking the admission of 2, again, brave students, Black students, Vivian Malone and James Hood. Wallace had campaigned on the slogan of segregation now, segregation tomorrow, and segregation forever. And he only moved aside when confronted by the Alabama National Guard, who was ordered then to intervene by President Kennedy. So a couple of thoughts here in conclusion. Brown ended de jure segregation in public education, but Brown did not impact de facto segregation. 10 years after Brown, only 1.2% of Black school children in southern states went to school with white children. And outside of Texas and Tennessee, the percentage was less than 0.5%. Today, many of our urban schools are as racially segregated as they were before Brown. Prior to Brown, Little Rock Central High School was 100% Black. Today, at that time, prior to Brown, it was 100% white. And today it is almost 100% Black. Policymakers will need to wrestle with the impact of de facto segregation on our country. And so here's the question I want to leave you with as we move into the panel. If we believe that de jure segregation is harmful to students, how should we think about the de facto segregation in many of our schools? Our panel then will help us begin to think through these with actual stories. Judge Hamilton will now moderate this panel. And so I turn it over to him. Judge Hamilton.
Yes, Attorney Garten, thank you very much. And I agree, those were very powerful images. Just the thought of the National Guard having to escort children to school, I think is an experience that no one viewing this tonight, I would assume, has experienced. But thank you. I also want to thank you for your thorough outline and your thorough presentation tonight, not only on Brown versus Board of Education, but the other cases you mentioned, and explaining the context, history, and indeed the strategy that went into the development of this area of the law. And yes, you're right. And the next we'll have a presentation. Like you said, Brown versus Board of Education was not the end of the story. For many, it was just the beginning of the story. And tonight we're going to have presentations by Judge Emily Gould Chafa and Judge Odell McGhee. And I also invite the audience to submit questions and to submit their experiences into the question answer box. And so we can take a look at those, and others may benefit from their experience and their questions. So Judge Emily Gould Chafa spent most of her legal career in state and local government practice. She retired in July of 2019. However, she remains actively involved in numerous professional associations, including service as chair of the Iowa State Bar Association Diversity and Inclusiveness Committee. Judge Chafa attended Wartburg College for 1 year and then received her BA degree from Drake University in 1982. She received her Juris Doctorate degree from Loyola School of Law in Chicago. She is licensed to practice in Iowa and Illinois. She is actively involved in a number of professional associations at the national, state, and local level. These include the Iowa State Bar Association, the Polk County Bar Association, the Blackstone Inn of Court, the American Bar Association, Judicial Division National Conference of Administrative Law Judiciary, Civil Rights and Social Justice Section, and also the National Association of Women Judges and the Iowa Organization of Women Attorneys, IOWA. Judge Chafa is a longtime member of the Iowa Supreme Court's Interpreter Advisory Committee. She is an active member of the Infinity Project, a multi-state group advocating for gender equity on the bench throughout the 8th Circuit. She frequently presents CLE programs on a variety of topics, focusing on diversity, equity, and inclusion, the importance of preserving the rule of law, voting rights history, language assets, judicial ethics on and off the bench, and administrative hearing processes. Please welcome Judge Chafa to the Iowa State Bar Association People's Law School. Judge Odell McGhee was born in Liberty, Mississippi in 1952. He attended the University of Illinois and graduated from Cornell College in Mount Vernon, Iowa, where he received his Bachelor's of Arts degree in secondary education and math. Upon graduating from Cornell College, he attended Drake University Law School and received his Juris Doctorate degree in 1977. Judge McGhee has also studied in Europe at the College of University of Copenhagen in Denmark. Judge McGhee is licensed to practice law in local, state, and federal courts. He was elected to the National Board of the National Bar Association and was president of the Iowa National Bar Association for over 10 years. He was elected regional chair of the National Prosecutor Association. He has served several terms on the executive board of the Iowa State Bar Association and the Polk County Bar Association. He has served 4 terms on the Iowa Supreme Court's Commission on Continuing Legal Education and was a temporary examiner with the Iowa Board of Law Examiners. Judge McGhee was elected president of the Iowa Judges Association in 2011 and served on the executive board for those 5 years. In that position, he was the first African-American elected to the executive board and president of the Iowa Judges Association. Judge McGhee recently retired and now serves as a senior judge in Polk County, Iowa. He is a member of Corinthian Baptist Church, and also Judge McGhee provided the inspiration for the Monumental Journey statue at 2nd and Grand Avenue, which was constructed in memory of the founders of the National Bar Association, the country's predominantly African-American Bar Association. So please welcome Judge Odell McGhee to the Iowa State Bar Association People's Law School. All right, very glad to have you all. We're just about, okay, everyone's right. Right, so I'll start, and like I said, folks from the audience want to put their questions in the questions, and I'll try to get around to those as well. But what a wonderful presentation, and I'll start with you, Judge McGhee. Can you tell us when and where you attended school, and what was the racial makeup?
Well, thank you very much, Henry and Tim, for some very, very good information on the Brown versus Board. Henry asked that I come on and talk a little bit about my earlier time in Liberty, Mississippi. I was born in a small southern town, just about, I would say, if you come over the Mississippi-Louisiana line, the first town that you would get to coming up on Highway 55 is Liberty, Mississippi, or Macomb, Mississippi. That's where I was born, and in 1952. And the school system was segregated at the time. It was segregated for as long as I lived there. Now I lived there through 7th grade before my parents moved north. But Henry, I thought it would be interesting to at least give you some idea of what the school system was like. being born there, we first went to a one-room schoolhouse that some of you might have attended, but most of you probably did not. And that was a one-room black school called Brown School. And all of the African Americans in about a 25-mile radius went to Brown School. Many of them were allowed to ride the school bus, but it was a segregated school bus. My grandfather drove the bus, and he would come around and pick up as many as the black kids as he could to take them to Brown School. And we went there with grades 1 through 8 in this little small school with a potbelly stove for the cold months of the year. And we all went there. And before you could transfer to the high school was also segregated, but it was in town. And so the bus would come and pick up the young children and take them to Brown School and take the kids from 8th to 12th grade onto the high school. My parents were, my mother was a maid and my father was a sharecropper and later a planter of trees, tree planter. And they worked very hard to keep a lot of the social issues away from us. In other words, we were not allowed to go to the movies because African Americans could only sit on the second level. We weren't allowed to have ice cream at the local ice cream stand because we would have to go around to the back to have a cone of ice cream. We could not enter the establishment. If you went to the store to get some shoes, you could not try on the shoes. And you could not bring them back if they were too small. So that was the kind of situation. We didn't have to get off the sidewalk, but there were white and black fountains and, excuse me, there were drinking fountains in town, and there were colored fountains and otherwise fountains that African Americans could not drink from. But in terms of the school system, we had a teacher in the earlier grades, 1st through 3rd. She actually lived in many of the homes of the children that went to that school. They didn't even have a place for her to stay. She would, in a sense, come in and stay 1 week or 2 weeks with this family, and then a couple of weeks with the next family. It's very typical of what many of you have probably read about in books, but that's the way it was. And Miss Mary Allen was her name, I can remember distinctly. And she was a very strict teacher. We got a lot of spankings because she believed in spanking. And you had to do your work and you had to go home and read your books, even though you read by lamplight, but you had to go home and get your homework and you were expected to have that work done every day. And she was very strict about it. And so I went to that school system for 3 years, and then we went, they unified the school system, but all they unified was they sent all the African Americans to Central High School. That was the name of it, Central High School in Liberty, Mississippi. And so all the grades, all the black kids went to that school. And a cousin of mine was the principal of that school, Professor Mcgee. And he was a very strict man as well. Very, very strict guidelines, very hard on basics, and worked really hard to try to get you to learn. I must truly say that looking back on those days, segregation was was all around us, but we lived in a separate society. And really, in truth, I tell people all the time, I don't know how you could tell the distinction between a black home and a white home, because all of us economically was about the same, but somehow people knew where to go and where not to go. And there were lynchings in the community. I had a few cousins that were lynched, and it burned down one of my family homes. And as well, I had an auntie that ran out of town, and my father ultimately was ran out of Mississippi in 7th grade because he had a debt that he could not pay, and they threatened to kill him. So he had to leave on the midnight train to Chicago. But anyway, I don't know what more to say, but it was a segregated system. The education system was not very good. All the books that we got at our school were the books that the white students had gotten old, and they were getting rid of them, so they sent them down to the black school. So all of our books we never got a new book. All of our books were always old, and you can see it in the front of the book. It would have the names of the individuals who owned the book or used the book the year before, and you would see many times that you would get the book 3 to 5 years later. So there'll be 3 names above your name before you'll be able to write your name in the book. And so that's, in a nutshell. I won't talk too much about it. If you have questions, I'll be more than willing to ask, but that's where I started out.
All right. No, lots of questions, and I'm sure the audience may have some as well. But I want to ask Judge Chafa the same question. When and where did you go to school, and what was the racial makeup?
Sure. I grew up in small town Iowa, rural Iowa. My father was a United Methodist minister. We're commonly known as PKs, or preacher's kids, for some of you in the audience. And the Methodist church denomination worked like this. Ministers were expected to move from one town, one church to another every 5 or 6 years. So I went to kindergarten in Missouri Valley, Iowa. That town may be familiar to some of you. Yeah. Attended 1st through 5th grade in Oakland, Iowa, and then attended 6th through 10th grade in Hawarden, Iowa, far northwest Iowa in Sioux County. All of these schools were, as Tim referred to earlier, as de facto segregated. So you may be wondering, why is a person who looks like me a panelist in part of this conversation? Obviously Caucasian, WASP, which means white Anglo-Saxon Protestant, as I've mentioned my father's profession. But because I grew up in small towns in rural Iowa in the 1960s and 70s, our schools really were segregated because the population of these small towns where we lived was primarily white, Western European, very homogeneous community, and we weren't really exposed to anyone other than people who generally looked like us, had similar backgrounds. Now, fast forward, 11th grade, my father was assigned to a church on the east side of Des Moines. And so I attended North High School in Des Moines, Iowa, my junior and senior years. And that was a very diverse school in many ways. And that's the reason why I'm part of this panel and honored to be included with this group. The North High School I attended in 1976, 77, 78. If you may recall, that was soon after the Vietnam War. And there were a number of refugees from South Vietnam, from Laos, the Thai Dam community, and Governor Ray, the governor of Iowa at the time, welcomed these refugees from Southeast Asia to Iowa, and many of these families settled in Des Moines and attended North High School with me. So North High School was not only racially diverse, but was also ethnically diverse, with these recent new Iowans or recent migrants from Southeast Asia. And I greatly value that opportunity to attend school with so many people from so many different backgrounds. And I'm forever grateful that we moved to Des Moines from the small towns, and that I was able to attend North High School and have all these wonderful experiences. I'll stop there.
Okay. All right. Thank you. I think we're gonna dive into both of these. Judge McGhee, I want to go back to you, and this is all interesting because, you know, some of the things you talked about were clearly after Brown versus Board of Education was decided. And so my question to you is were you, well, let me start here. Were you aware of the schools that the Caucasian students went to compared to the schools that you and your family and your friends went to? And how did you deal with that situation? How did the community deal with that situation?
Well, and yes, of course, we were on one hill and they were on another hill. We were very close proximity to each other, specifically after third grade. And yes, we knew. I sometimes look back and wondered how we did that. But I tell you, my world was all just the folks that I was related to. And we knew that we got the used books, and we knew that our education was secondhand. And we knew that many of our teachers were not as qualified as those that were in the other school system. We knew all that, but we dealt with what we had. And I don't know how to say it other than to say it that way. People accepted that where they were, they thought that's where they belonged. And didn't do a whole bunch about trying to change it at the time.
How, today I know that, African-American parents will lecture their students about how to behave when stopped by the police. They'll give you the lecture, you have to work twice as hard to get half as far. How were you introduced to that system back in the day? You don't just grow up, going to this fountain and not that fountain. How were you instructed to go to different fountains and to not try on shoes, to go through the back door of restaurants? How were you introduced to that?
You were introduced first by your grandma or your mom, who told you, don't do that. Who will tell you, no, you can't go in there. Who will tell you, no, you can't try on in the shoes. We're going to the store, we're going to buy the shoes, and you can't try them on. So make sure. My mother used to carry a little string or something, and she would measure my feet with the string. And then she would go into the store, and when she bought the shoes, she used that piece of string to determine the appropriate size of the shoe. I mean, I'm saying, we learn how to get around all of these types of issues. You learn to, when you go into a store and there's a person who's not African-American in there, they're going to get ahead of you. And they automatically did it, and you just stood back. And as I said, until the late 60s, basically most people just simply went along because you had to work with these people. My father had to work with the people he sharecropped with. And, if you caused trouble, they were going to hear about it before 6 o'clock because everybody was gossiping and talking, and you were going to be in trouble. And Daddy didn't want no trouble. He wanted to support his family, and Mother didn't want any trouble with Miss Rovilla. And so basically they did what they were supposed to do and lived. And that's just the way it was. So yes, we knew about it. We knew about all the racism. When I was 3 or 4 years, well, I would say 5, 6 years old, the young men, the white young men in the community, and I used to swim in the river together. But when we got to be 8 or 9, you notice that they pulled away from you. You couldn't go to their home anymore, and they didn't come to your home anymore, and you couldn't play together anymore. But you just accept it. That's the way things were.
Okay, interesting. Okay, and I know you were young, but growing up, did you hear stories about Emmett Till, and how did those stories impact you?
Very badly, because we did not only hear stories about Emmett Till and other folks who had died coming to Mississippi in the 60s and 70s, but we had families. When my auntie got involved with the and my grandfather became he was elected to be a poll watcher. And we just knew he was going to die the morning he had to go to the polls, because the polls was in the white church. And they had told him he better not come up to that white church. But he decided he was going to go, and he went up there. But, we just knew he was going to die. We didn't expect to see him again. The whole family gathered in that morning as he was going up to watch the polls to make sure that Black folks started to vote. What I'm trying to say is that, yes, and then my other cousins, they were involved in the movement. Their house was burned down, and my cousin and her baby, she was pregnant, they were burned up in the house. My other auntie, cross was burned on her lawn, and then her house was burned the next week, and she had to leave Mississippi and go to New Orleans. I mean, all this stuff was going on around. But you know what? My parents, they didn't really want us to know. They tried to keep it a secret. But, we knew. But, the grown folks didn't talk about it around the kids because it was embarrassing.
Okay. Wow. I'm going to go back to Judge Chafa for a moment. And Judge, I want to dive into your educational experience, going to the all-white school in Missouri Valley to the integrated school of North. How did you transition? How was the transition? Was it weird? Were you prepared for it? And how did your educational experience differ?
Oh, I'd say, as I mentioned, the small town rural, which happened to be all white schools, were, we were just all the same, basically, and Des Moines, and of course, there were small towns where exactly what Judge McGhee said, everybody knew everybody and everybody knew everybody else's business and all those details. But no, I really didn't know what I was walking into when I first walked into North High. So I will admit, I walked down the hall, I was like, oh my goodness, there's all these people who don't look like me. Oh, this is interesting. But I guess here's what I'll say. Here's what I thought then, and I firmly believe it now, and I thought about it, more and more over the past few years. But we all benefit from integrated, diverse schools. We all benefit when we're in public school. I guess I'm a product of public school education with people who aren't exactly like us. We learn from each other in so many ways, not just in the classroom, but in all the extracurricular activities, in the locker room, in the girls' restroom, I'll admit it, all kinds of interesting conversations occur there. So we all benefit from integrated, diverse schools. We all miss out if we don't have the opportunity to attend schools. And really, I wish, my education would have been integrated K through 12 and all up if we didn't have the opportunity to attend a diverse integrated schools. I guess I'll just say, first day in the choir, there's all, people talk about using your voice, but this is literally, using your singing voice and blending with voices that didn't sound, exactly like mine, but appreciating, the wonderful sound we all made as a choir, on the cheerleading squad. Everyone, we didn't all look alike, and we brought different skills to the squad, and the same, of course, in classrooms, classroom discussions.
All right, and I'm gonna ask you this question. I'm gonna ask Judge McGhee a somewhat related question, but so you're at the integrated school now. How were race relations at the school? Was it still, the white kid sat with the white kids, the black kid sat with the black kid, or was it a true integrated experience?
Well,
that's the Judge Chafa. Then I'm going to connect to you with a slightly different question, Judge.
Yes and no. So I would say we were together in like choir, and like I said, that mentioned the cheerleading squad, and of course the sports teams, and in classrooms, and some other activities. I think we sat together, but it was more of, we sat with our group, either the music nerds or the football players or the basketball players, and that kind of group. I remember it more as groups based on our interests, rather than based on color.
Okay.
And it's been quite a while. I might be remembering it incorrectly, but that's the way I remember.
Okay.
The school.
And Judge McGhee, we have several questions in the, for lack of a better term, the question box. But they want to know, how was your experience different? Was it different when you moved to Chicago? And then again, how was it different in Iowa, in Mount Vernon, and then later in Des Moines?
Well, I went to a almost all African-American junior high when I moved to Chicago. And then I went to a high school on the north side of Chicago that was predominantly Jewish. And it was a totally different experience. It was really hard to get used to the process, but it was a good school. It was a great school, the Von Steuben High School in Chicago. And it was devoid of a lot of the strife. I mean, it seems that we all got along pretty good, actually. Even now, I still communicate with lots of my high school individuals. But I think, as I tell people, you know, when we walked out at Von Steuben High School, we walked out in support of other schools in the city, never in support of what was going on at Von Steuben. It was a good experience, an excellent experience. And then when I came to Iowa and to Mount Vernon and Cornell College after the University of Illinois, another distinctive impression of the state. The people at Cornell were about the same as Cornell. I mean, at Cornell were about the same as Von Steuben. They were all really nice people. And they really, you know, opened up and tried to make us welcome there. And, you know, we were allowed to do all kinds of things that we could have not probably done at other schools. So my experiences were very, very good in high school and also at the Cornell College in Mount Vernon, Iowa.
All right. I'm going to grab another question from the audience here. Oh, they disappeared. Oh, no, here they are. Let's see. Answer.
How did they get around Brown? They got around Brown by simply ignoring it. In Liberty, Mississippi, Brown was ignored. In Mississippi, it was ignored in the whole state. They didn't ignore it, and I guess no one really sued on it. But many of the Southern schools, even after Brown was passed, you know, even 20, 30 years later, they still have not instituted the Brown provisions. And so, and I'm sure you understand that, they simply ignore them, ignore the provisions of the law.
Let me grab some more here. Just give me a second to read these. One comment, an interesting book about growing up in Mississippi during the period is Coming of Age in Mississippi by Ann Moody. If folks are interested in learning more, we answered that one.
Let me just answer one other thing, Henry, about private schools.
Yes.
I go to Mississippi yearly because I still have family there. And how do they deal with private schools? Now, in the 1980s, the federal government started to make sure that all the schools were integrated. And a lot of the whites who were going to white schools, they left the white school system, public school system, and they went into private schools. And so that's what happened was they went to private Christian academies, and they left the public schools. They left the public school system. It was totally African-American or totally minority, with a very, very small amount of whites remaining. But you'd be surprised now in Mississippi, the private institutions are trying to get the African-Americans who play football and basketball to go to their institutions to make their teams really good. And so they're actually recruiting kids from the public schools to go to these private institutions. But right now, someone said it earlier, 80% of the schools in Mississippi and places like that are still segregated.
Okay. All right. Here's a question. Well, several people have asked a similar question. And since I know that both of you have looked into this area, I guess I'll ask both of you. The question was asking for your opinions, and I know your opinions do not represent the views or opinions of any past, future, or present employer, of course, but what's your opinions on the pushback here in Iowa to the 1619 project and the pushback regarding the issues surrounding critical race theory? And this wasn't mentioned, but also House File 802. If either one of you care to discuss that.
I can jump in. I think the pushback is very unfortunate. If we all benefit from learning more, we all benefit from learning more about American history, about world history. I know personally, I've been inspired to read more books, and I've said this phrase, more often in the past year or two than I'd ever said it in my entire life, was, why didn't I know that before? Why didn't I learn that in school? Why didn't I already know this? So of course I go read, more books to learn more about the full history. And I guess I was so impressed with Nicole Hannah-Jones being a native Iowan, Waterloo, not Des Moines, but we still claim her, of course, in talking about her experiences. That's just so enlightening for all of us. And I think the more we learn about the full history of the United States, and the more, students can discuss it, maybe not in a classroom, in the lunchroom right now, but at home or out or somewhere else, then of course the more all of them will benefit from learning all the diversity of the United States and the full history.
Well, I have done research, severe research on the critical race theory, and I'm very disappointed because if anyone took the time to really get an understanding of what the critical race theory and 1619 are all about, it is not about what many of the politicians say it's about. It is not a situation in which they're teaching inequality or saying Black kids are not as smart as others. All that stuff is untrue. The tenets of the critical race theory simply say the program is asking that the majorities in America understand and really seek the truth about what occurred and not sweep it under the carpet. I did a lecture about 2 months ago at a program here in the state of Iowa on the critical race theory. And I was talking to a lot of teachers from the state of Iowa. And I asked them, what African-American history do you teach in your classes? These were history teachers, social study teachers, and they told me nothing. They didn't know who Alexander Clark was. They didn't know who Edna Griffin was. They didn't know who Emma Koga were. They didn't know who any of these people, N. Ray Ralph. They didn't know anything about these people, and they didn't teach it because they said basically it was, I said, well, how do you teach the Civil War? They said, we teach it as the war between the states, economic. You talk about the slaves? No, not too much. We don't get into, how the slaves felt. We just simply teach it as an economic issue. And so, what I'm trying to say is that many of these towns, folks are growing up not knowing anything about Native Americans, African Americans, or any other people who've come into their communities. And it tickles me because we expect to know about George Washington and we expect to know about, Thomas Jefferson, but they don't know anything about anybody, anybody who has any involvement in your community. I mean, they could at least teach them about Martin Luther King or somebody, but I mean, many of these students are getting no information on African Americans who have made a difference. Of course, they might know Barack Obama, but it's from a negative perspective.
Yeah. Or you raise a good point, or even the common experiences, this, both my parents grew up in the segregated South and probably attended segregated schools throughout their educational careers. But I've never told the stories about not being able to try on shoes and grandparents having to measure your foot size outside the store and just go take a chance that the shoes will fit. So I think you're both correct that all of this will be valuable information to give us an understanding of the history of our country. Let's go back to some more.
I guess I'll just add in while you're looking at questions, Henry, if you don't mind if I interject. Yeah. So all of you students, actually students in high school, but also lifetime students, I hope everyone else attending are lifetime readers, read more books. Read about Harriet Tubman, the real story. Read more books about some of our founding fathers with the rest of the story, as Paul Harvey used to say. Read more books about Fannie Lou Hamer. I mean, the list goes on and on and on. Ida May, Ida B. Wells, Gertrude Rush, for example, all the other National Bar Association founders. I mean, and of course, read the 1619 project information. Just all of us can take it upon ourselves to educate ourselves, and then hopefully our families, friends, circles of influence to help all of us learn more about the full complete history.
All right. Well, great. One is a comment, someone indicating, a participant indicating that she grew up in Michigan, the daughter of a basketball coach, and had been raised to understand racial issues and had been raised not to judge others. And she saw that as a benefit of her upbringing.
Well, I tell people all the time, I don't think most folk in the world, and definitely not in the state of Iowa, are necessarily racially prejudiced. I think most of them, many people in this state and other states across the United States simply have not had the opportunity to get to know any African Americans because their experiences is somewhat, as Emily has stated hers were in the earlier years. They just don't have any contact. So they don't, they don't really know about it because it's just not a part of their everyday lives. And they don't even really talk about, that's what I'm saying. Race should be discussed these days. I mean, I'm hoping that all families would discuss race, just talk about it. What do you think of Black people? And I'm hoping it's in a positive vein, but we really need to have a conversation in this country about what it means to have different races and ethnicities in our community. Yeah. And we really need to have that conversation. And so no matter who you are, no matter what your race makeup, talk about, I'm hoping that you're talking about all these things, as Emily said, the people who are coming to this country, about the Latinos and their effect, and the Indians and their effect, and Blacks and their effects. And I mean, we will come to really understand people if we can understand what they're about.
Yeah, I agree. We have a question. Where is the best place, or what are the best resources to learn more about critical race theory and 1619 Project? And you all can add on, but I would say, buy the book, the 1619 Project by the Iowa author. And then critical race theory, I'm stumped there because it's not as broad as people think. It's mostly taught on college campuses. So where would you find resources?
Just put CRT in your computer, and it will show you a massive amount of information, and a whole mass amount of difference in terms of how folk interpret it. I go sometime on computer and just look at the different views as to what CRT means, and there's at least 50 different perspectives on it. So you can pull it up anywhere, and of course your library. But definitely go online and just put CRT, and I guarantee you get more information than you really want.
Yeah, and the important thing to remember this: the CRT, as to my knowledge, has never been taught in the high schools or the grade schools in any state in this nation. It's been primarily taught at the university level and the law school level.
Absolutely.
And here's another one. Another person suggests the 1619 Project book is available, and also that the 1619 Project, the New York Times Magazine issue, is probably still available online, and that there's a number of online programs or webinars on critical race theory that are accessible on YouTube. And let's see if we can get one more in here. Okay, 1 second. It's gonna take me a while to read this one. Until I can go.
While you're waiting, you want to thank you for having this program. And as I said, it's very enlightening and it's very, very good. And Tim, of course, did an excellent job. Emily, wonderful. So.
Oh, yeah. No, both of your inputs have been extremely valuable. So I guess I'll read this. This is an anonymous attendee. Until I came to college, I had not really learned extensively about the civil rights movement, Brown versus Board, or anything of the like. Of course, we learned about Dr. Martin Luther King Jr. in school, but we never learned about the full history, like you said. Why do you think this is? Is it because, like you said, the lack of understanding about critical race theory? Also, how would you compare the media as it is today as compared to the media around the time of the civil rights movement? From what I've learned in my media and politics class, I would say that it is very sad how media is no longer newsworthy. Okay. You all have any comments on that? In fact, this person probably should have asked you all the questions from the whole program. Did a much better job than I did. Go ahead. Anyway.
Well, go ahead, Emily.
Oh, I was gonna say, I think we all answered it before. We just didn't know the textbooks that we used in public school, whether they were the original textbooks or the leftover used textbooks, don't include the full history of the United States. They include what the textbook publishing companies want to include, and that's why it's so important to expand the horizons and read other books and or hear from other speakers.
Sure. And to demand, go ahead, Judge.
I think, today we can find more information on lifestyles of differing types of people. I mean, our movies and everything seem to be more willing to bring storylines. And, I noticed CBS Morning News and some of the other, they have programs now with minorities. They talk about them and their plight and their situations. I think if you just open up your ears, you can probably just pick it up, because I think we're seeing the news media and the entertainment media doing more and more on the plights of minorities. I laugh all the time because, and I grew up, of course, with most of you on Fathers Knows Best and Andy Griffin and all that. And I don't even watch that stuff because it's just such a lie. I mean, it just was so untrue. I mean, in those towns and places, there had to be a block every now and then, but you never saw one. And so, what I'm trying to say is that we grew up with this perspective that TV brought to us, and it was not true. And that's not the way people live. And so what I'm trying to say is now we are seeing more and more storylines that are just typical of the way people live. And I think, we're being educated if we just open our ears and hear it. I really believe that.
All right. All right. Well, we're going to, I'm going to mention a few more comments and then give you all an opportunity to make some closing comments or observations, and then we'll turn it back over to Attorney Garten. I do want to address something that Emily said about the textbooks. You can't, in Milwaukee, we ran into a situation where the textbooks that they were using in Milwaukee spent more on Madonna, so I'm dating myself, when we were reviewing them, I spent more pages on Madonna than the Civil War and the Civil Rights Movement. And we were able to encourage the Milwaukee Public School District to be more inclusive of the topics that they taught and included in the textbooks that they were using. Anyway, some comments before we hear final comments from the judges is that there is an Iowa State Bar Association CLE program on House File 802 and CRT that is available at iowabar.org. The CLE program was presented on December 15th, 2021, is available on demand. And for those of you not familiar with House File 802, that's the law that censors how the history of racism and discrimination and sexism can be taught in the schools. One person indicates that Derek Bell, legal scholar and well-known civil rights lawyer, has written extensively on the issue of critical race theory. And we have one other personal experience from an attendee who was raised in the white section of Waterloo. Her parents were farmers, but often welcomed diverse students into their home. And she feels that was a blessing to have these interactions. And okay. And we got other ones. The ABA has a discussion about a critical race theory entitled A Lesson on Critical Race Theory that another attendee recommends. All right, so with that, oh, we got more coming in, okay.
Well,
several folks wanted to say thank you to both of you for your thorough discussions. And with that, I believe we started with Judge McGhee. So why don't we begin the end with Judge Chafa? You can have your closing remarks. Thank you.
Sure. Thank you so much to all who are attending now live and to those of you who will watch the recording later. Think about this. We all benefit from integrated, diverse schools and lifetime experiences. We all miss out if we don't have those experiences, if we don't take the initiative to learn more about the full history of the United States and to teach our children. The children listen, the children have to be carefully taught, and buying children's books about Ruby Bridges and the Tulsa massacre in 1921, and just all these historical events that we've mentioned that you or your children might not be learning in school are easily accessible to you to buy. I guess one other thing I'll say, attending North High School changed my life, and I'm almost choking up again talking about it because it was such a valuable experience, and I still benefit from that diverse high school as I connect with North High again and marvel at the amazing students there, especially the newly migrated students new to the U.S. and new to Iowa who are there. So I'll just mention one other thing. The Law Day competition in 2004 celebrated the 50th anniversary of the Brown versus Board of Education decision. And the theme of winning photography that year was what we would have missed. And it was excellent photography by a high school student who happened to be a recent immigrant from Bosnia. And it was photography showing, the benefits of diverse schools and her theme of what we would have missed if we didn't attend integrated diverse schools. And that photography exhibit was on display at the Small Claims Court in Polk County in Des Moines, Iowa for many, many years. So everyone who visited Small Claims Court for one reason or another benefited from viewing that photography. So thanks again for including me in this program, and appreciate all the insightful questions and comments, and especially the opportunity to serve on the panel with you, Judge McGhee, and with you, Judge Hamilton.
Okay, thanks, Judge. Judge McGhee, final comments?
Well, thank you, Judge Hamilton and Judge Chafa and Tim. I just want to say, I think, as it's been stated, I appreciate my experiences at Von Steuben High School and integrated school, and as well at Cornell. I think those situations made me a very well-rounded person, and I'm hoping that the people I impacted, that they were able to get an understanding of what my experiences were like, and taught them to appreciate something that were different. I also lived abroad a couple of years in Europe, in Norway and Denmark, and I know when I lived up there, the people had never seen an African-American before in some of those areas that I lived in. And, they still write and call and talk. And, they really enjoyed the experience of getting to know someone different. And I am a strong advocate that if you don't know anybody different, try to get to know someone just to appreciate a different experience from your own. And so I appreciate being on the panel, and I thought it was very good. Thank you very much. And that's about all.
All right, and I'm going to read a couple more comments, then we're going to turn it over to Attorney Garten for action steps and a summation and things that we can do to improve our communities and learn more about American history. We have some comments from a librarian that she works in a library, and you can request that your library contain more diverse resources and have them available in libraries, even in small towns in Iowa. And another person writes in on the topic of books for kids. A good one is Black Heroes, a Black history book for kids, 51 inspiring people from ancient Africa to modern day USA. And then we have one final one, that should conclude it. One person wanted to advise us that he learned about diversity, equity, inclusion at the YMCA and the Y camps back in the 1960s. So with that, Attorney Garten, we'd like to turn it over to you for action steps and closing comments.
Yeah, well, that was a great panel, and thank you very much, Judge Hamilton and Judge Chafa and Judge McGee. Very, very good panel, and thank you for the good comments. I'd like to also thank the sponsors who provided this support for our program today. And as we worked through this today, I'd like to leave you with 5 suggestions going forward. The first is to learn more about the struggle for civil rights and racial justice. Read and listen. And so you heard a lot of those good comments today, both reading books, but also developing relationships with others that are not like you and learning from their experiences. Second, make an effort to serve vulnerable people in your community. What Bryant Stevenson, the author of Just Mercy, calls proximity with the poor. It's a very good thing to do. Third, contribute to groups that are moving the needle. There are still organizations that are very involved in these efforts. Fourth, advocate for social justice. Find areas that are important to you. And finally, Bryant Stevenson leaves us with the admonition of love, what that needs to drive our motive in these kind of activities. And with such efforts, we will participate in what President Lincoln called for in his second inaugural address. And I thought it would be appropriate to end with that. With malice toward none, with charity for all, with firmness in the right, as God called us to see the right, let us strive on to finish the work we are in, to bind up the nation's wounds, to care for him who shall have borne the battle and for his widow and orphan, to do all which may achieve and cherish a just and lasting peace among ourselves and with all nations. And with that, thank you very much for watching this program. On behalf of the Bar Association and the other sponsors, thank you.
Thank you, Tim, for the wonderful idea, and thanks to the rest of you for participating this afternoon. And this session will be recorded and available. So all of you who are teachers, please feel free to share it with your students. You can use it anytime. And attorneys, anyone else who's listening today, please feel free to share the recording once it's available, and it will be available on the iowabar.org website. Thank you again.
All right. And on behalf of the sponsors of this Black History program, the Iowa State Bar Association, the Iowa chapter of the National Bar Association, the Polk County Bar Association, and the Iowa Organization of Women Attorneys, we thank you for attending. We hope you enjoyed the rest of your evening, and please stay safe and look out for future programs on the Iowa State Bar Association's People Law School. Good night.